Questions to you. Are the members of your family aware of your transfer here to The Hague and your state of detention in Scheveningen detention unit? Or would you like me to inform some member of your family about this?
I informed them personally. They saw me off. They all know about it.
Thank you. And the same question in relation to your embassy, the embassy of Serbia and Montenegro. I take it that they are aware of your presence here in The Hague?
At the airport, I was met by a lady from the embassy, but I wish to ask you to inform the embassy that I'm having problems with the assignment of counsel, defense counsel, and that they should assist me as far as they are able to.
All right. In this regard, Registrar, please, could you block, copy this part of the transcript? In other words, from page 24, line 5 to where I will finish making this statement. And the statement that I am making is that this part will be communicated by the registrar of this tribunal. It will be copied, it will be extracted from the transcript and copied and communicated by means of the not verbal or in any other manner that the registrar deems fit to the Secretariat of the Embassy of Serbia and Montenegro here in The Hague for the information. Thank you. So you've heard me say that this part of your statement, together with mine, will be communicated to the Secretary of your embassy, and then it's up to them to do anything if it's the case of doing anything. Right. Now you may sit down.
Thank you.
You may sit down. Now, as accused before this tribunal, you enjoy a certain number of rights. These rights are incorporated in the statute of this tribunal, but also relatively in the rules, which are a reflection of what is contained in the statute. I am going to ask the registrar to read out aloud to you Articles 20 and 21 of the statute of this tribunal, which list the rights to which you are entitled. And when I say you are entitled, it means that you are entitled to them from now until the end of the proceedings. Thank you. Yes, Mr. Registrar.
Thank you, Your Honor. Article 20 of the statute reads as follows. Commencement and conduct of trial proceedings. Point 1. The trial chambers shall ensure that the trial is fair and expeditious, and that proceedings are conducted in accordance with the rules of procedure and evidence, with full respect for the rights of the accused and due regard for the protection of victims and witnesses. 2. The person against whom an indictment has been confirmed shall, pursuant to an order or an arrest warrant of the International Tribunal, be taken into custody, immediately informed of the charges against him, and transferred to the International Tribunal. 3. The trial chamber shall read the indictment, satisfy itself that the rights of the accused are respected, confirm that the accused understands the indictment, and instruct the accused to enter a plea. The trial chamber shall then set the date for trial. Point 4. The hearings shall be public unless the trial chamber decides to close the proceedings in accordance with its rules of procedure and evidence. Article 21 of the statute reads as follows. Rights of the accused. Point 1. All persons shall be equal before the International Tribunal. Point 2. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. Point 3. The accused shall be presumed innocent until proved guilty according to the provisions of the present statute. Point 4. In the determination of any charge against the accused pursuant to the present statute, the accused shall be entitled to the following minimum guarantees in full equality. A. To be informed promptly and in detail in a language which he understands of the nature and cause of the charge against him. B. To have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. C. To be tried without undue delay. D. To be tried in his presence and to defend himself in person or through legal assistance of his own choosing. To be informed if he does not have legal assistance of this right, and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it. E. To examine or have examined the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as a witness against him. F. To have the free assistance of an interpreter if he cannot understand or speak the language used in the International Tribunal. G. Not to be compelled to testify against him or to confess guilt. Thank you, Mr.
Thank you, Mr. Registrar. Now, having gone through these two articles, it is obvious that I have to make sure of certain basic matters. Mr. Miletic, could you stand up again, please? You've heard the registrar read out these two articles, which basically embody the minimum safeguards, the minimum rights for a fair trial, minimum rights that you enjoy too. Do you understand the importance of these rights?
Yes, I do.
I want to make sure that you have received a formal copy of the indictment in your own language. Could you confirm that, please?
Yes, I have received such a copy.
I take it that you have read it, and if you have, then I would like to know from you whether you have understood the import of its contents. Basically, whether you are aware what it alleges against you and what it charges you with.
I have read the indictment on a number of occasions, but I have not understood it, and I'm surprised by the legal and factual description of the events contained in the indictment, and this is an issue that I will have to clarify when I have the opportunity of conferring with my defense counsel.
But what I need to know today is whether you have, it's not whether you agree or disagree with the contents of that indictment. When I say whether you have understood the contents of the indictment, is whether in your mind you know precisely what is being stated in that indictment and what is being brought as a charge against you. Whether it's clear in its wording, whether it's clear in the message it's supposed to convey to you as the accused, as the subject of that indictment, or one of the subjects of that indictment. It's not whether you agree or not agree, that will be another matter.
Your Honour, could I assist in this matter? I've got some instructions about that topic which might help to clarify the position. Mr. Miletic has, as indicated, has been given the indictment, has read it on a number of occasions, and instructs me that he remains unsure of the significance of some of the parts of the indictment, both factually and legally, so that he is able to understand the language of the indictment, but he's not sure, and he's not sure of what the legal implications of that are, or what the precise factual allegations are. And Your Honour, in following from that, it appeared to me, at least, that it was the sort of matter that needed to be clarified with competent counsel. And it's for that reason, among others, that he's so keen to have the issue of counsel resolved, having had counsel engaged before who had spoken to him, and also liaised with the learned prosecutor in this case. That troubled him, and that's the reason why he answers as he does. I think he understands Your Honour's question, and his answer was really adapted to answer Your Honour's question.
All right, I take it that as a consequence of this, he will subsequently inform us that he is not in a position to enter a plea today.
That's correct, Your Honour.
Is that a logical follow-up?
Yes, it is, Your Honour.
All right. So for the time being, I think I am going to adjourn on this particular point, and when we meet again for the second part of this, or for the follow-up of this initial appearance, I will repeat the question to you, Mr. Miletic. Let me continue. Thank you for clarifying that, Mr. Morrissey. Yes, for the time being, Mr. Miletic, you may sit down. Mr. Gvero. And the same question to you. You heard the registrar read out Articles 20 and 21 of the statute of this tribunal. Do you understand the importance, the significance of the rights that are secured in your interest by the statute and also by the rules of this tribunal? Or do you need any one of them explained to you?
I do understand, and I expect that I will be given these in writing. If they are not in the papers I have.
You can ask the registrar to provide you with a copy of the statute and also a copy of the rules, which are available in your own language without any difficulty. There are others who have asked for these, and they are always made available. Again, I would like to have a confirmation from you that you have been served with a formal copy of the indictment against you in your own language.
Yes.
Have you read it?
I have read it.
And do you understand its contents? Do you understand what it alleges against you and what it charges you with?
As a literate man, I have read it and I see what the contents are. However, I can also see that there are many things which I can in no way connect with myself. Things like a joint criminal enterprise, murder, which is completely foreign to me, and other things. In spite of that, I do understand the content, although I cannot accept it.
All right, Mr. Poles, I saw you moving. Would you like to make any submissions in regard?
Not at this stage, Your Honor.
Okay, thank you. But otherwise, you know what you're being charged with and what is being alleged by the prosecution. It's not a question whether you agree with it or not. It's whether you understand what it contains.
Razumem.
I understand you, Your Honor, but I felt the need to say what I said. I do, however, understand the content.
Thank you. I would like to know, now you may sit down, thank you. According to the normal procedure, supposedly I should now proceed with the reading out in full of the indictment. But this is a right which many a time the accused waive for practical purposes. I would like to know whether there has been any consultation between you, Mr. Morrissey and Mr. Poles, and your clients. In this regard, whether you require me, in other words, whether your clients require me to read out the indictment in its entirety, or whether we can be satisfied with the information that I gave earlier on the contents, on the gist, substance of the indictment. Yes, Mr. Morrissey.
Yes, Your Honour, that later course can be adopted, and Mr. Miletic waives his right to have, I'm instructed that he waives his right to have the whole thing read out. We're satisfied with the short procedure that Your Honour's indicated.
Thank you, Mr. Poles.
Your Honour, yes, Mr. Gvero is similarly satisfied with the shortened procedure.
I thank you. Mr. Miletic and Mr. Gvero, you have heard what your counsel have stated, and as a result of that, first of all, I thank you for having waived this right. There will not be the need to proceed with the reading of the indictment in full. The next step in the initial appearance of today is that I proceed with asking each one of you to exercise the right that you have to enter a plea of guilty or not guilty to each of the counts that have been brought against you. Now, our rules envisage three possibilities. One possibility is that when I ask you whether you want to enter a plea and what plea you would like to enter to each of the 5 counts that you are charged with, you can decide to enter a plea today. You can also decide not to enter a plea today and reserve this right to enter a plea till later. In which case I need to advise you straight away that our rules allow for a maximum period of 30 days within which you can enter a plea. The third possibility, which does happen sometimes, is in case you decide not to enter a plea at all. If, in other words, you remain silent. In that case, I will enter a plea of not guilty on your behalf. But then that, of course, will be done according to the modalities laid down by our rules. Mr. Miletic, I would like to know first and foremost whether you have discussed this matter with your duty counsel, Mr. Morrissey, and whether you are prepared to enter a plea today. I take it from what was stated earlier by Mr. Morrissey that you are not, and that you will not be entering a plea today. Is that correct?
Yes.
So my duty is to remind you that you have a 30-day period within which to decide what plea you want to enter. As a result of your not entering a plea today, there will be a follow-up to this initial appearance, which will be more or less the 30th day from today. I mean, I will give you all the opportunity. If, however, you are in a position to enter a plea before, and you would like us to convene the follow-up of the initial appearance, please advise or instruct your counsel to contact my registrar, and then we will reconvene the initial appearance at an earlier date. I thank you, Mr. Miletic. You may sit down. Registrar, for the record, the pre-trial judge declares that he's heard Mr. Miletic, accused Miletic, state that he does not wish to enter a plea today. And I now move to Mr. Gvero. Mr. Gvero, I would imagine that you have discussed this matter with your counsel appointed to you to assist you for the purpose of today's initial appearance. And my question to you is whether you wish to enter a plea today, or whether you would like to do as Mr. Miletic, reserve the right to enter a plea at a later stage, but within the 30-day limit that I mentioned earlier.
I have discussed it both with the counsel of my choice and the kind gentleman who has been assigned to me today, and I have decided to plead today.
I thank you, Mr. Gvero. Then we'll need to go through the formal procedure. The way I will do it is as follows. I will go through the counts one by one. Tell you only what the count charges you, what crime is incorporated in the crime. And then I will ask you a very simple question, and this is how do you plead to that particular charge, as guilty or not guilty? And do you have a right to answer guilty or not to answer at all? So we'll start with the first count. The first count against you, Mr. Gvero, is one of murder, this being a crime against humanity, punishable under Article 5A of the Statute of this Tribunal. How do you wish to plead to this charge? Guilty or not guilty?
Not guilty.
Thank you. The second count brought against you in the indictment is also one of murder, however this time this being a violation of the laws or customs of war, punishable under Article 3 of the Statute of the Tribunal and recognized by Article 3.1a, murder, of the Geneva Conventions of 1949. How do you wish to plead to this second count of murder? Guilty or not guilty?
I'm not guilty.
Okay, I thank you. And the third count against you is one of persecutions on political, racial and religious grounds, this being a crime against humanity, and which includes, according to the prosecutor, murder, cruel and inhuman treatment, destruction of personal property, forcible transfer and deportation, punishable under Article 5H of the Statute of this Tribunal. How do you wish to plead to this third count of persecutions? Guilty or not guilty?
I can't see myself in any of this. Not guilty.
I thank you, Mr. Gvero. The fourth count brought against you in the indictment is of charge of inhuman acts consisting in forcible transfer, this being a crime against humanity, punishable under Article 5I of the Statute of the Tribunal. How do you wish to plead to this fourth count? Guilty or not guilty?
This is incredible. I have nothing to do with this. I'm not guilty.
Okay, I thank you. And the fifth and last count against you is a charge of deportation, which is brought as a crime against humanity, punishable under Article 5D of the Statute of this Tribunal. How do you wish to plead to this fifth and last count of deportation? Guilty or not guilty?
I will prove I have nothing to do with deportation. I'm not guilty.
Okay, thank you. You won't have to prove anything, Mr. Gvero. The onus of proof is entirely on the prosecution, and the prosecution needs to prove beyond reasonable doubt. And I can assure you that this tribunal will only convict an accused person if the prosecution has succeeded in proving its case and each and every count beyond reasonable doubt, failing which there will be an acquittal. You may sit down.
Ja ću dokazivati.
I will prove my innocence, Your Honor. Thank you.
I think you need not do that. It's not a burden that you carry. Yes, so the position is as follows, Mr. Registrar, for the record. Mr. Gvero has entered a plea of not guilty to each and every one of the 5 counts brought against him. Now, Mr. Miletic, but particularly Mr. Gvero. Mr. Miletic, you will remember this for the purpose of the follow-up after you have entered the plea. That if you have entered a plea of not guilty, it doesn't mean that that decision of yours is irrevocable. It doesn't mean that you have closed upon yourselves all doors to a possible change in the plea. You may, at a subsequent stage, if you so desire, change your plea and you may change your plea in its entirety to each and every one of the counts brought against you, or only to one or more of those counts. But I am sure that the lawyers that you will have assisting you later on will be able to assist to enlighten you on this. While we are at this, I also wish to inform you of the following. There is a very apt important rule in our set of rules of evidence and procedure, which I need to bring to your attention. That is Rule 63. I will read out, and please do follow me carefully. Questioning by the prosecutor of an accused, including after the initial appearance, shall not proceed without the presence of counsel unless the accused has voluntarily and expressly agreed to proceed without counsel present. If the accused subsequently expresses a desire to have counsel, questioning shall thereupon cease, stop, and shall only resume when the accused's counsel is present. That's the first part of Rule 63. The second part is the following. The questioning, including any waiver of the right to counsel, shall be audio recorded or video recorded in accordance with the procedure provided for in Rule 43. I don't need to go into that. And the prosecutor shall, at the beginning of the questioning, caution the accused in accordance with Rule 42A3. Rule 42A3 basically imposes on the prosecution to caution you of your right to remain silent, and that any statement that you may make will be recorded and may be used in evidence. Having told you that, I will proceed with other matters. Wish to inform everyone that very soon I will appoint a pre-trial chamber which will schedule a status conference to be held within 120 days. When I say pre-trial chamber, pre-trial judge, who will schedule a status conference to be held within 120 days of this initial appearance pursuant to Rule 65 bis A of our rules. There will be several of these status conferences, you will find out. The purpose of a status conference is twofold. First of all, it is a visit to organize exchanges between the parties, prosecution and defense, on various matters, such as disclosure, for example, or discovery and disclosure matters, and to facilitate expeditious preparation for trial. Secondly, the pre-trial judge, whoever that will be, will have an opportunity to see you in person and ensure that you are being treated well, and that you do not have any complaints or special or particular requests that you would like to make that you haven't been able to. Later on, you will be informed of the exact date of the first and subsequent status conferences. Also, I will be giving instructions to the registrar for TWIT to fix a possible date for trial. But then, of course, when I say as early as possible, that depends on various matters, particularly what will come out in the course of the pre-trial process. In the meantime, and until we come to trial, in accordance with an order that I have issued, you will remain in custody. That's for the time being. But I wish to inform you that in terms of our rules, Rule 65 in particular, you have a right to file an application for provisional release. I'm sure that your respective defense counsel will assist you with this if necessary. I beg to differ with what was stated earlier. If the matter of assigning definitively the counsel of your choice means that you consider it as a bar to filing an application for provisional release, I wish to inform you that I will accept such an application even if it is written by you personally on a simple piece of paper, on an ordinary piece of paper, provided you hand it to the registrar for onward transmission to the pre-trial judge or to the trial chamber, pre-trial chamber. So if this matter takes a long time to resolve, you have a right to seek the assistance of the trial chamber, asking for a provisional release even on a personal initiative, upon a personal initiative. Very important, and this is something that has arisen out of a comment that was made by one of the accused. That's the disclosure of the supporting materials which accompanied the indictment, which, as you know, was kept under seal. You have 30 days from today within which to disclose that material. If I read Mr. Gvero correctly, he doesn't wish to wait for his counsel to be assigned. He wants that material to be disclosed to him at the earliest. I don't know if Mr. Miletic joins in that request, or whether he would be happy if the material is disclosed to his lawyer to his counsel once that counsel is assigned. But perhaps either Mr. Morrissey or Mr. Miletic can enlighten me on that.
Your Honour, I hadn't we hadn't a firm position about it at this stage. on the one hand, he clearly does want to have the materials in his hand, but time starts to run once that material's furnished, and in relation to responding to it. And if the issues of his counsel are not resolved, then he suffers a potential for prejudice in that regard. And what I had in mind was to have that matter adjourned, which is not a wholly satisfactory solution, but it might allow some discussions to take place between the prosecutor and myself, which we haven't had time to have as yet. The prosecutor may take the view that they were prepared to waive the commencement of that time running, but I haven't asked them to do that as yet, and I don't expect them to respond
No, I don't think I
on
don't.
their feet. So those are the reasons why I hesitate about it. Yes, we do want the material, but we don't want it to be furnished in a way that causes time to commence running now, because really he needs to talk to those who are competent to advise him about it.
Yes, I thank you, Mr. Morsi. Mr. Pauls, do you want to consult your client on this matter?
You want to know? I can say I have already consulted with Mr. Gvero about this issue. My learned friend Mr. McCloskey, on behalf of the Office of the Prosecutor, has very kindly indicated that the prosecution are in a position to serve the Rule 66A(1) material today, and then it can, of course, be made available to Mr. Gvero. A consequence of that, of course, is that Rule 72 will kick in, and there will then be 30 days in which to file any preliminary motions or other motions, indeed, pursuant to that rule. One way of proceeding would be, it seems to me, for the prosecution to serve the supporting material on the defence today, and then the 30-day requirement being postponed or adjourned pursuant to Rule 127, which of course allows for the variation of time limits in the Rules of Procedure and Evidence. I have already spoken to my learned friend Mr. McCloskey about this, and he indicates that as far as the Office of the Prosecutor is concerned, there would not be much resistance to an extension of that time limit following the eventual assignment of permanent counsel to Mr. Gvero. So perhaps one formulation could be that pursuant to Rule 127, the 30-day time limit in Rule 72 is extended to perhaps 30 days after an order from the registrar assigning permanent counsel to Mr. Gvero.
Yes, Mr. McCloskey, would you like to comment on that, since you've been brought into the issue?
Yes, Mr. President. I have spoken to Mr. Pauls, and there are certain logistic and practical issues, as you're well aware of. Having been here many years now, I've been through this before, and we have problems giving it material out at this stage because it goes to the jail and naturally gets taken apart, and then the new counsel comes in looking for the material and can't find it, and it's hard to expect new counsel to go to the jail and resurrect it. And so then Ms. Stewart ends up having to copy this material over and over again. So, but I think Mr. Pauls and I have worked that out, where he's going to copy the material, have it in a nice untouched package for permanent counsel, and that way that General Gvero can have the material. Okay. And we should be able to work that out. As Mr. Pauls said, I don't think we need any formal rulings about deadlines or 30-day periods as yet. My biggest concern is to keep these deadlines on the same track so that one accused doesn't get ahead or behind of the other, because then you will start getting filings, one after another, instead of being able to deal with them, together. So hopefully we can keep this together. And just while we're on that subject, the prosecution, just to let you know and counsel know, we plan to move to join the two generals to the case of Mr. Beara, which is currently in front of Judge Bonamy.
I thank you, and that basically, once you've made that statement, we'll have to think and discuss later on whether it's wise to have that case transferred over to Trial Chamber 2, or have this case transferred to Trial Chamber 3. So if there's going to be a joint. And but for the time being, I will leave it at that. If there are problems with the disclosure of the 66A1 material within the 30-day limit, Mr. McCloskey, please, I'm tasking you with the responsibility of bringing that to the notice of the trial chamber.
Yes, Mr. President, of course, and just to let you know, I am very well aware of this issue of counsel. I have been communicating at length with Mr. Petrusic and Mr. Višnjić, who formerly represented General Krstić in a similar Srebrenica case, which is, without getting into it, the problem that the registry is grappling with. And this is an issue which, of course, needs to be resolved, and that's what you will learn about as you talk to the registry. But that's the biggest issue I think we have right now, and once we get over that counsel issue, the generals will be comfortable, as will the prosecution, and will be able to go forward.
Okay. I thank you.
Your Honor, just for clarification then, again, Mr. Gvero is, of course, very keen and anxious to receive the Rule 66A1 material, and I'm grateful to my learned friend Mr. Pulaski for indicating that it can be carried out subject to a copying of the material to be made available to subsequent counsel coming into the case. Just for the record, however, can I clarify that that material is received, will be received by the defence on the understanding that the 30-day time limit in Rule 72 will not kick in or come into force, at least until after permanent counsel are assigned on behalf of Mr. Gvero?
I can assure you, Mr. Poles, that in these matters there has always been cooperation between prosecution and defence, and if that is lacking, the trial chamber will step in and make sure that the right balance is secured.
Very grateful, Your Honour.
Okay, thank you. Next. Again, this is information that I need to impart, which is of a legal nature, but you ought to be aware of it, Mr. Gvero and Mr. Miletic, that pursuant to Rule 72A, which has already been mentioned by both defense counsel, the accused will have a 30-day period within which to file any preliminary motion it has received once it has received all the supporting material in accordance with Rule 66 that I mentioned earlier. I don't think it's the case of expanding on this. I think what has been said covers the entire subject. We are approaching the end. Is there any matter, Mr. McCloskey, that you would like to raise on behalf of the Office of the Prosecutor?
No, Mr. President.
I thank you, Mr. McCloskey. And Mr. Morrissey, is there anything that you would like to raise on behalf of your client?
Just two matters, Your Honour. Firstly, with respect to the provision of the Rule 66 material, what we indicate is that we'll have further discussions with the prosecutors. It's likely we'll reach an agreement that's acceptable to all parties, and if we can't, then we'll move the chamber and see if the chamber can assist. Secondly, I'm grateful to the indication that Your Honour gave concerning provisional release, and it's comforting to have that. We understand the registry will move with all expedition to resolve the issue of counsel, but however there seem to be, in my limited knowledge of this case, some genuine issues that have to be resolved, and there is room in good faith to differ, it seems to me, so that it could be the case that it's not resolved immediately, even with good faith being shown, and for that reason we bear in mind what Your Honour said, and it may be that that some sort of application might have to proceed in the absence of the matter being resolved. It's not ideal, because I understand.
It's not ideal, but it's a matter of personal liberty, personal freedom, and I would not stick to any formality when it comes to that matter.
Thank you, Your Honour.
Thank you. Mr. Poles, is there any other matter that you would like to address on behalf of your client, Mr. Gvero?
Yes, and it may be my fault for not entirely understanding the position in relation to the 30-day time limit in relation to Rule 72 in the way that Your Honour described it. Of course, it may be possible to come to some sort of arrangement with the prosecution that 30-day time limit can be extended upon receipt of the Rule 66 material. However, it seems to me on a reading of Rule 72, it wouldn't be open to the prosecution and the defence to simply unilaterally agree to extend the 30-day time limit, and it would need an order from the trial chamber or from the court indicating that that can take place. And my reason for raising it now is it may be that it seems almost certain to me that it's not going to be possible to comply with the 30-day time limit in view of the fact that permanent counsel have yet been appointed on behalf of Mr. Gvero, and in view of the fact that the prosecution have indicated that they can or are in a position to serve the material fairly imminently. I would urge the court to give an indication or provide an order that the 30-day time limit will not apply in relation to Rule 72 for the purposes of Mr. Gvero in terms of filing any preliminary or other motions pursuant to that rule.
Mr. Poles, I mean, don't ask me to give any rulings now. I mean, I will give rulings when it's ripe to give such a ruling. But I think when I said that even if there is a disagreement between you, the trial chamber will step in to redress that and ensure the adequate balance. I think I was sending a loud and clear message. But I won't go beyond that for the time being. I mean, of course, even if you agree amongst yourselves, the procedure to follow is to notify the trial chamber of that agreement, and then of course that will be followed by an ad hoc provision and order. But,
yes, but my understanding is that the prosecution and the defence had already received, arrived at a provisional agreement in that the time limit could be extended for a period following the assignment of permanent counsel, and in those circumstances I was trying to remove the need of having to file any written motions later by simply dealing with the matter already today.
Yeah, but Mr. Powers, I wouldn't waste my energies on this matter any further. I don't think it should be of any major concern to either you or to Mr. Morrissey. I mean, I don't think that the various trial chambers of this tribunal have been unreasonably unreasonable in approaching or dealing with these matters. So
it's certainly not my experience, and my experience is that in view of the
doesn't even cross my mind.
Sometimes substantial delays in terms of bringing these matters to trial, it's almost invariably the practice that the Rule 72 time limit is extended. The simple reason for raising it now would be to try and avoid any unnecessary filings later by simply dealing with it by way of an oral ruling today.
I appreciate that, Mr. Poles. Unfortunately, I'm not in a position to know what is involved because I was not the confirming judge in this case. So I never received the supporting document. So I don't know. I mean, I've been confirming judge in other cases, and I had volumes to read. So I don't know what this involved, but presumably it does involve quite a little bit of material. But again, we'll come to that problem if it becomes a problem. Because for the time being, I take it that it's a difficulty that the prosecution has, but which it can meet with comfortably also within the 30-day limit. So let's any further.
Your Honour, just this, and I hear, of course, everything that Your Honour says.
Okay.
The issue now is not, of course, the volume of material that the prosecution are likely to serve. It's the fact that I won't be in a position to file any preliminary motions on behalf of Mr. Gvero because I'm not permanent counsel. And it was just preempting the fact that permanent counsel is not yet. But I hear what Your Honour says, and we can, of course, leave it now.
I am also sure, Mr. Poles, that the registrar is aware that that would be a problem if and until he has assigned counsel to both parties, and that if it is necessary to assign or reassign you again, if anything solely for the purpose of Rule 72 motions, there's nothing to stop him from doing so. So basically, let's leave it at that. Because for the time being, that is not a problem. It may become a problem. If it does become a problem, I'm sure that this is something that we can find a solution for.
Well, no, I very much hope so.
Thank you.
I don't think it would be appropriate for duty
I don't
counsel to
think so.
file Rule 72 motions on behalf of an accused.
I don't know.
We'll
We'll see. Last but not least, Mr. Miletic. I just want to make sure that you haven't anything else to tell this me as the pretrial judge. Do you wish to tell me anything else? In particular, what I want to know is whether from the moment you were taken into the custody of this tribunal, whether you have been treated well and whether you are being treated well in the detention unit. I know that you have been here for a couple of days only, but...
Your Honor, I really have no objections to the way I have been treated up to today. Everyone has been acting professionally, and I respect that.
If there are any problems, I want to let you know that one of our functions as judges here is to receive here any complaints that you may have in relation to your either state of health or your state of detention in Scheveningen. So don't hesitate to put us into the picture if there are any of such concerns. You may sit down. Thank you. Mr. Gvero. Again,
thank you.
Same question to you. I would like you to confirm to me whether you have been treated well from the moment you have been taken into the custody of this tribunal, particularly in relation to your transfer and also to your detention in Scheveningen.
Yes, in a very civilized manner, with a very good relationship, and I really have no objections. My expectation is, let me repeat, that it will be possible to reveal the truth at this tribunal.
Thank you. You may sit down. Basically, there is, I see that there is no further business to transact. Took us almost 2 hours, 1 hour and 3/4, but we have covered the entire territory. I thank you all. The initial appearance comes to an end. Here there will be a follow-up as regards your client in due course and within the 30-day period. Thank you.
All rise, feu vous levez.